So as Fred mentioned, this is an ethics program, and it's my desire to actually have this operate more like an ethics workshop than it is an ethics lecture. And so included in your materials, there are several scenarios, all of which have questions and none of which have answers, which is deliberate on my part because I didn't want to skip into the answer as we were working our way through the scenario and short cycle the conversation part of things. So here's really what we're going to cover. There will be one additional piece of material added early on. But the idea is actually professional responsibility issues in estate planning, and we're only going to focus on really 2 items, but we're going to warm up before we get into those 2 by using another one. And that's really going to be considering conflicts of interest as they come up in the context of estate planning, and then the second one is the question of unauthorized practice of law, and we'll touch on that at this particular time. So here's the one that doesn't relate to conflicts directly. Here's the fact pattern, here's the scenario. Long-standing client has begun to slip mentally. He seems to struggle with handling qualified plan transactions that were easy for him just a year ago. You also notice he struggles to find the right name for the right grandchild. Today he asks you to change the terms of his revocable trust. The terms currently provide that 10% of the trust goes to his church. He proposes that that number should now be 25%. Do you help the client accomplish the change in the estate plan? Now, included in all of your materials, I think, in my outline, I have included a variety of law-related information. So you'll see references and inclusions of model rule provisions. You'll see references to and inclusion of the restatement 3rd of law on lawyers and governing lawyers. And you'll also see in there the ACTEC commentaries to the rules. The Association, Trust and Estates Council. And they have actually tried to provide a very useful commentary to the rules, which they see as being primarily directed to litigators and not primarily helpful to transactional lawyers. And so I would commend those to you, and as I mentioned, I have included references to this. I've also included in many of these scenarios, I have deliberately tried to tug at your heartstrings a little bit by representing the design and pattern to be a noble cause, right? So in this particular case, it seems like a noble thing to go from 10% to 25%, 10% to the church to 25% to the church. And so I've deliberately pulled in that direction so that you may be inclined to say, well, I think we can be able to do that, or we should be able to do that, because it sounds like a good idea. And I just want to warn you that that's there. Okay. So as I ask my students all the time, what's the question you got to ask? What do you think the right question is? To get to the answer of, do you help the client accomplish the change in the estate plan, what question you got to ask?
Does he have capacity?
Yeah, the question is a question of capacity, right? And so I told you this was the warm-up, right? This is the kind of easy one. So under the model rules, 1.14, subsection A simply says, it is reasonably possible you maintain the client-lawyer relationship with a client who has diminished capacity. And then when the lawyer reasonably believes that the client has diminished capacity as at a risk of substantial physical, financial, or harm unless action is taken, then the lawyer may take reasonably necessary protective action. That's the question, I guess. Are we there yet in this particular client? I'm not sure that we are necessarily.
Yes, you might ask him why, what his motivations are, what financial situations kids are in, things like that, to see what's behind it.
I think the first.
I'm glad people are jumping in, by the way.
If he made it to your office
Yeah.
and presented this proposition to you, I would say that he has some degree of capacity. So I would want to know from him, who are the other beneficiaries of the trust, and are they in agreement with what the change that he wants to make?
Okay.
But what if the treasurer of the church drove him to you?
I told you we were starting with the easy one. You know, that's a little harder one. It's interesting. I'm going to give you this one story.
Constantly.
What's that?
I constantly call people.
Oh, the wrong name. Yeah. That doesn't work. Okay. So I have to tell you on the question about the treasurer of the church driving them there and kind of ushering them in. There is a case in my home state where something very much like that happened, and it was an undue influence case, diminished capacity undue influence case, and the Court of Appeals said that whatever presumption might have arisen in that context of undue influence was undone when the individual who drove the client to the lawyer and sat there during that conversation said, by affidavit, we didn't engage in any undue influence. I use that case every year when I teach wills to illustrate how courts can get so many things so fundamentally wrong. I mean, if you've engaged in undue influence, don't you also think you would lie about it? But we took the either harder one or the easy one, depending upon.
The most important question, whether it's your church.
Yeah.
Does he have a living spouse?
Yeah, so there are lots of questions that it seems to me they're all going to focus on the same issue, though, which is capacity. And you're right, you don't have to have a lot of capacity in order to make the estate plan, and you don't have to have a lot of capacity in order to remake or to revise that estate plan. All you have to have is general knowledge of your assets, general knowledge of the natural objects of your bounty, general understanding of what you want to do with your property, and then you have to be able to put all those together. Do you understand these assets are generally yours, these are the natural objects you're bound, including them or you're not including them? All of those relate to the question of capacity. Now, when you, in this particular instance, it's also wise, it seems to me, to think about not only capacity but also the possibility of undue influence. Because even though we might not want to think that, it is possible that undue influence can influence outcomes even in favor of good and right causes.
Does his church have a good litigator?
One of the issues in California, anyways, capacity is no longer you either have it or you don't have it. It's a whole range of diagnoses and a range of capacities that the court focuses on in terms of that issue.
Yeah, now the other part to this too is well before someone would lose the capacity that would be necessary in order to have testamentary capacity, they will lose the ability to handle financial transactions. Financial transactions, from the elder law folks that I speak to from time to time, financial transactions they appear to us when we repeat them time and time again as fairly routine transactions, but they're actually fairly complex transactions. And so it is easy for individuals in earlier stages of dementia, well before they have lost testamentary capacity, to lose the ability to engage in those kinds of even what we would perceive as relatively simple financial transactions. And sadly, there are lots of organizations that prey upon just that reality. When my mother, I mentioned this in one of the earlier classes, my mother has dementia and she's had it for some years. And when some of that started, she would get solicitations from charitable organizations and she would think them to be bills. And in part because some of those charitable organizations actually made them look like bills. And they preyed upon that reality of the early stages, financial transactions. If you think about dementia or incompetency, the first thing that goes actually is kind of financial transactions. And you have to get much farther down the pyramid before you lose testamentary capacity, all right? Now, this is the ACTEC commentary summarized. Generally, you should not prepare a dispositive instrument if the lawyer reasonably believes the client lacks capacity. I think you'd need more evidence in this particular case to reasonably believe that the client lacked capacity. But because of testamentary freedom, a lawyer may assist a client whose capacity appears to be borderline and take steps to preserve the evidence of that capacity. That's a helpful commentary, in my judgment, on the rules for the estate planning lawyer. And then in cases involving a doubtful capacity, the lawyer should consider, if available, procedures for obtaining court supervision of proposed estate plans, any substitute adjustment judgment. But that's only if the lawyer reasonably believes the individual to have lacked capacity or to lack capacity at that particular time. Okay, conflicts of interest. So the ethical source of the conflict of interest rules is the duty of loyalty. It's the client is entitled to place one's complete trust in the lawyer who owes a corresponding duty of loyalty to the client. And I think it's helpful to think about conflicts of interest as being of two types. There is a conflict of interest that arises or can arise between the lawyer and the client directly. And then there's a conflict of interest that arises between the clients of the lawyer so that the lawyer is unable to serve both clients with the duty of loyalty. Understand what I mean by that?
Family.
My students sometimes have a hard time. They understand the idea of conflicts, but they don't understand exactly where they appear and how they may be treated differently. So in this example, I'm talking about the first type of conflict. Here's the first fact pattern. Rather wealthy, elderly woman, close personal friend of your mother and father, whom you've known for 40 years, and whom you have represented in several legal matters for the last 15 years, has requested that you draft her estate planning documents. So far, so good, right? Her children, and along with them, her grandchildren have largely abandoned her. There's no question about her competence. As she describes what she wants to do with her property, she tells you that she's always been very fond of you and your family. She respects greatly how you have raised your children. As she continues, she tells you that she would like to provide you with the resources that would enable you to send your children to a Christian college. You have 5 children, 2 of whom are adopted from China. You anticipate that it'll cost more than $500,000 to educate all of them at Christian colleges. She's going to give you $500. She wants to give you enough money to be able to do that, and it's going to represent 10% of her estate.
Not in California.
No, you can do it, just have to get it.
Well, can you draft her wealth transfer documents? Good answer. All right. Can you accept a gift if the documents are prepared by another lawyer providing independent counsel?
Yes.
So model rules provide or prohibit soliciting such a gift or preparing the wealth transfer documents unless you're related to the client. Can you accept the gift if prepared by another lawyer? Here's the comment to Rule 1.8. It allows for acceptance of a gift from a client if the transaction meets general standards of fairness. But examples are holiday presents and tokens and gifts of appreciation and the kinds of things that you might receive as a small token of gratitude. The ACTEC commentary provides that the lawyer cannot assist an unrelated client in making a substantial gift to the lawyer or a person related to the lawyer, and the substantiality of the gift gets considered in light of the size of the estate and the designated recipient. So what would you do in that circumstance?
Refer them to another lawyer.
What would you say to the individual?
Tomorrow, I just say,
Well, you can explain California, it's required by statute that if you prepare a document for a client who is leaving you something, you have to get an independent certificate of review.
who's a caregiver or someone like that.
Who also knows the client and the situation, is that what you're talking about? Or somebody who's already in a position?
It must be made to a caregiver, it must be an independent certificate of review, or the request is void.
Okay.
And that includes family members, so.
Family members of you,
Yes.
of the lawyer, right, any related party to the lawyer.
I guess you just tell the client and give them the option, say, I can draft your documents, but I'm not including that gift. If you want that gift included, here's a referral.
Does that solve the problem? Do you think that solves the problem? Are you comfortable with that solution to the problem?
Let's restate the solution, because I'm sure it couldn't be heard in the back.
Oh, the solution would be, and I think I like the first part of this, I can't do that.
Yeah.
That's an easy one. What about the next part of it, which says, if you want to do that, you're going to have to see another lawyer? Play that conversation out just a little bit longer. What's going to happen?
What do you want?
Who should I go see?
I think you need to give them more than one referral.
I think you ought to give them,
Yeah. Multiple, yeah.
yeah.
It shouldn't be in your office.
It better not be in your office. And I would suggest it's probably better not to use a law school classmate either in this circumstance, right? So, because what we're after here is not just to check the box, it wasn't me who drafted it, right? What we're after is true independence, right? We're after somebody else who is engaging in that kind of assisting of the client, who is able to give complete duty of loyalty to that client, and whose interest is not in any way drawn away from the client to serve any other interest. Does everybody understand what I'm talking about? That's what I mean when I'm saying that you have a conflict of interest that's between the client and the lawyer directly, right? I mean, there's some possibility here that you're not going to do a faithful thing to the client because the so-called faithful thing to the client in your mind is also faithful to you. It is to your best interest. That kind of conflict of interest can exist in the world of estate planning. It doesn't exist as often in litigation, right? But it can exist when long-term relationships are developed in the context of estate planning. And at some point you can lose your objectivity. And when you lose the objectivity so that you are not fully serving the client, but you are self-interested, now you've got to get genuine objectivity or independence in there.
Suppose that this person doesn't desire to educate your children as a draftsman, but wants to give money to a fine Christian college where you are a trustee.
Yes. Yes. I almost did that one, by the way, because I think I'm going to do exactly the same thing that we're going to do in this particular situation. Exactly right. I am going to say, I can't do that for you because I am a trustee of that particular college. I encourage you to do it, but I'm not going to do it. Find somebody else and engage in some independent counsel.
But if the individual had an independent relationship with that college, couldn't you still do it?
I'm not saying you can't do it. I'm saying I wouldn't do it. And I'll come back and talk as people come back in.
I was going to say, a large part of people who come to me are fellow members of the same church
Yeah,
that I go to.
right,
And they end up, or the same denomination.
Right.
And they end up wanting to make a small or large gift to the church
Yeah, and I think-
denomination. I really don't, although I usually, if they don't know me, I disclose I'm a member of the board or whatever.
yeah. I'm not saying you can't do it. I'm just saying that I would be reluctant to do it in my particular position as a trustee, and I'm thinking through that as a trustee. I'm thinking, am I actually serving this client, or am I also self-serving here? And that's the question I need to answer. I think the rules let you do it. I don't think there's any question about that.
I was prosecuted for this kind of thing
Okay?
by the Illinois Attorney Registration and Disciplinary Commission on multiple counts initially, and while the case was pending, the Illinois Supreme Court issued an important ethics ruling that said the ARDC cannot throw a blunderbuss charge against attorneys, but have to be specifically rooted in a particular alleged violation of the rules of professional conduct. So all but 2 of the charges then went away on an amended complaint. And that left 2 charges against me. What I had done is I had been, like this wealthy elderly woman, I had been her attorney for over 30 years, her whole family's attorney. Her only child had predeceased in a tragic suicide. And she only had extended family that lived hundreds of miles away, which she was fond of. But I had continued to serve her, and we had a friendship, and she valued not only my professional service, but my visiting her and taking a personal interest in her, because she was lonely. She lived in the Chicago suburbs. And late in the relationship, my brothers and I started a private foundation to build a new Christian camp on inherited lands in Wisconsin. We're from the Chicago area. And she was interested in learning about that. And so I gave her information, but I didn't solicit her because we were not raising funds.
Right.
We didn't have government approval yet, so I never asked her for anything. And then my law partner who did the estate planning retired, and she asked me to take over the estate planning instead of just doing her income tax and contract work and litigation. So I also became her estate planner. Well, at some point she said, I'd like to favor your camp, your family's private foundation, 501c3 approved, right? So that raises the question, can I do this? So as you pointed out, Illinois has an anti-scrivener rule. So that if she had wanted to write me or my relatives in, I couldn't have done it. But this was an approved IRS charity, even though I'm an officer and director of it. And I felt that the anti-scrivener rule did not apply. And on the eve of trial before the hearing board of the ARDC, the disciplinary commission dropped that charge, leaving only the general conflict of interest charge that went to trial. And after trial, I was acquitted. But it was 2-1. However, the one, it turns out, the one dissenter had been pressured after the trial completed. The staff attorney of the ARDC had pressured one of the independent hearing board officer, a member of the bar, to rule against me in an ex parte communication. And I know this because the chairman of the hearing board so informed me. So that's like tampering with the jury.
Right.
In this case,
Right.
the hearing board. So I was acquitted. It would have been 3-0 had the pressure not been applied. Now, I did see that I could be accused of a conflict of interest or undue influence. So what I did is I had various independent notaries public privately meet with my client before execution. And I instructed each of the various notaries, because there were several amendments, to interrogate my client as to whether I had solicited, asked for, pressured her in any way to make this significant gift, which was about 10% of her estate, to my family's private foundation. So I had at least that foresight.
Mm-hmm. Right, right.
And that proved to be very important in the decision of the hearing board.
It would. I mean, what you're looking for some kind of independent counsel, genuine independent counsel, or genuine evidence of independent decision-making on the part of the client. And that's what you're after. And I think in all of these cases we've been discussing, I think that there's a possibility that the lawyer can do all of that. I don't know that the rule would prohibit it. But I do think that in some places you run the risk of consequences if you do that. And, you know, I tell some people, I'm a lawyer for a reason. I'm risk adverse. And so I usually try to stay within the safe harbors when I can. Okay. Now, here we have a different kind of conflict situation. This is not a potential conflict between the client's interest and the lawyer's interest. This is a conflict between clients that the lawyer either serves or is being asked to serve. So here's the facts. You have handled several commercial transactions for your client. He's inherited a good deal of wealth from his parents and has, through several astute business moves, accumulated even greater wealth. Several years ago, his wife died. Today, he's informed you that he just got remarried. His wife's former husband died about 5 years ago. She has 3 children from her first marriage. She has some assets, but far less than your client. When your client called you to tell you that he had gotten married, he also asked you to draft the estate planning documents for him and for his new wife. His estate would trigger substantial federal tax, estate tax. Her estate would trigger no tax. He suggests giving each spouse an income interest in the property of the deceased spouse, and then that property would pass to the children of that first spouse to die. The question is, may you jointly represent both of them in preparation of the estate plan of each?
Yeah. You do it all in California.
All right, so here we got. This is the Rule 1.7, conflict of interest, current clients. Is there a conflict of interest between the clients? That's the first question. All right, the representation of one client will be directly adverse to another. That's how it's defined. Or there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to the other client. Does it fit within the definition? Then you get this question under 1.7. Even if there is a conflict, the lawyer may represent both clients if the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. The representation is not prohibited. I can't even remember what 3 is. And the fourth one is, each affected client gives informed consent confirmed in writing. That's good practice. Is that the common practice in California?
Yeah, that's the.
Well, since he,
The form I use to get the data, right after the data is the waiver of conflict document.
Okay.
since he didn't do a premarital agreement, I would suggest that he do a postmarital agreement with the conditions that he wants to include in the estate plan and his wife represented independently.
Okay. That could address those circumstances in particular because you get independent representation. Now, the downside of that is that you multiply the number of lawyers involved in the transaction. You increase the cost, but it doesn't sound like cost is a particular object there.
Part of it might, part of the consideration would be how the children get along.
Right.
Look at the family.
Right.
I need clarification. I don't remember reading that he had previously represented the new wife.
That's correct.
So how is that case any different than a couple who has only been married to each other? I don't.
No. It's not really that much different at all. I was just creating a fact pattern where there had been a long-standing relationship to one of the members of this family, of this couple, right? And so there is no doubt that that individual has been a client of this lawyer for a long time. Now we got a new matter to handle, and we have a spouse involved in that. And I don't disagree with you. It's no different than the situation that involves just the couple that comes to you right now, other than you have a lot of money involved in this matter. You've got a long history with one of the clients, and you have to take into account, in my judgment, that you have another client involved in this. The other client is the new spouse. And that client's interest in this particular circumstance can be adverse to the interest of your client.
To what extent do you take into consideration and involve other counsel in potential conflicts such as this, that you may inadvertently, in order to protect your posterior, you may inadvertently cause conflict in a current marriage over something that may happen after one of the spouses dies?
I think what you're asking is if you invite other counsel into this particular representation, does that, might that trigger or contribute in some way to an ongoing conflict, even a deeper conflict that actually works out? It's not a theoretical conflict at that point. It's an actual conflict, right? It's a good question, I think, that people have to ask. What do you do with this?
I think it might be helpful to think it first to discuss what actual conflicts are there, the potential conflicts here.
Okay. Go ahead.
The same issue could be, could wife pressure husband saying, I need money to go to my kids, or I need you to give some money of your money to me if we die. Those are the areas where it seems to be the conflict's going to arise.
Well, so one of the things that can happen now under our estate tax system is you can port the estate tax exemption to another spouse, right? Unused portion. In this particular case, you have someone who is going to use up all of his estate tax exemption. If he transfers the assets in the right kind of way, if he dies first, he could, if he dies first, we're going to use up all of it, probably, or we're going to port all of it to her, and then when she dies, his assets get the advantage of his exemption plus her exemption. So she actually has a valuable asset. She has the loss or the tax savings on $5.5 million right now. That's part of the conflict.
Well, I mean, it seems to me that she's got no downside to letting him use that. Just she's only got upside, because she's going to also have his income, perhaps. But I'm not saying there's not.
Yeah, but that's part of the negotiation. I mean, if these parties were, yeah.
And there's the word negotiation. No, there's, to mind, that's where you might have scope from potential to actual. Honey, don't you love me? And that kind of.
The other issues, of course, if he dies first, she can change the estate.
Sure.
And that is something I always disclose.
Right. That's true. And it can happen. Yeah.
Well, I mean, that's when you would be explaining to them about Q-tips and.
Correct, that's right. But
having both of them present in the room at the same time and explaining these
right.
potential conflicts, and then covering that in your engagement letter.
Exactly.
As well as the fact that you, everything that each person says is public knowledge.
We're coming to that one.
Okay.
That's right. We're coming to that one because it's a different issue than just the joint representation. We're going to come to the issue of communication.
I think it made some difference too, that it was the wealthy client that you represented, and you're sending significant benefits to the new poorer client. Mm-hmm. That's also, I think, very helpful in that kind of situation.
Right. I think the rules, in my judgment, address this in the way that, in a clear way, it tells us what to do, right? There is a possibility, there's a risk of one or more clients the representation being limited in some way, that their interests are in conflict, but the lawyer can still do it if the lawyer reasonably believes they'll be able to provide competent and diligent representation. And I think the lawyer can do that in this circumstance. But it has to be careful. But it has to be careful. It has to be thought out. It has to be considered. And it's not a check the box kind of thing. And I think at the end, we're told they have to have informed consent, and that informed consent has to be confirmed in writing. So that ought to be part of the engagement letter and the conversation.
The part I find troubling about the fact pattern is that he called and asked you to draft documents for her.
Mm-hmm. That never happened to you?
If they both called on a conference call and they both came to see you, that strikes me as being a lot different than he's telling you what to do for his new wife, and you haven't even talked to her.
Oh, no, I think that you're right. I mean, you can start the conversation. You can bring them both in, right? But then that's only where this starts, right? You're exactly right. But the phone call always comes from one of them. I mean, I've never heard of a situation where spouses were on a conference call together I've never heard of one.
I have.
Have you? You initiate it, or they initiate?
No, we have a phone together. They have
Okay.
lines in their house.
Okay.
We're older generation. Pick up the extension.
I think it's true that usually one spouse initiates it.
Yeah. All right. So here's the distinction that oh yeah, go ahead.
I just wanted to comment, at our initial, and Christine and I are in the same firm, at our initial meeting with the clients, we have a document called Joint Spousal Representation
Okay.
Agreement, and we have them sign it at that time, and it waives the conflict of interest, and it waives the attorney-client privilege.
Which is now the second one.
So we,
Right.
we don't wait until we don't really do the engagement letter, we have a fee agreement and all that, but we have it done at that time.
At the initial meeting.
At the initial meeting.
Right. But those are two different things. That's correct. The representation issue is different from the flow of information issue. So here's the fact pattern. Mr. and Mrs. Smith, been married for 20 years. You and your husband actually attended their wedding and have been close acquaintances with them since that time. You attend the same church. The membership's about 1,000. I just threw that in there. You've been in their home several times. Likewise, they have been in your home several times. They both approached you to do their estate planning documents. They stopped you while you were walking out one day. They hadn't had a lawyer look at them since just after they were married. You set an appointment to meet with them. At that meeting, they provided you with the necessary information, described how they wish to distribute their property. You draft the estate planning documents, you review those documents with them, you execute them, you send them on their way, and yesterday you received a call from the husband. After a few pleasantries, he informed you that he'd like to change his documents, providing for a $250,000 transfer to one of his trusted employees, Barbara.
Sure, you get your wife on the phone.
So, in the first situation, we dealt with just the joint representation issue, right? We didn't actually talk at that point about how we're going to handle information. But in this particular case, is there any concern about the joint? Don't go to the information yet. Is there any concern about the joint representation? Is there anything that causes you to believe that there is a substantial certainty here, that there's a substantial likelihood that your representation of one will materially harm the representation of the other? Is there any? No. Exactly. No. Not in the joint representation from the beginning, right? If you've got your joint representation issue, correct? Could you represent both of them initially?
Yes.
Initially.
Yes.
Got it? Absolutely, I think so, right? And this one, to me, is a little different than the other one because you were connected to both of them for a longer period of time. It wasn't one that certainly dominated the relationship between you, et cetera, which might create the possibility of you steering things toward the longer acquainted and much more well-client. So I think there's no question about joint representation under the rules at this point. But that's a separate issue from what you do with information, right? Joint representation is one thing. How you're going to share information is something that ought to be handled at the same time, but it's not the same thing, okay? So, could the lawyer have begun the representation jointly? I think the answer to that is yes. Restatement third provides this example of some sort, right? ACTEC rule, I put it on pages 8 and 9 of my outline. I don't know how it gets represented in your outline. It gets included there, the comment to Rule 1.7. But the second issue is establishing rules for the flow of information. What are the rules that are going to be established for how information is going to flow within the course of this representation? Joint representation under the rules does not, in my assessment, establish a presumption that all the information offered by one client will be shared with the other. Joint representation alone does not create that presumption. So you have to decide, is it going to be a keep all confidence rule, or is it going to be a share all confidences rule? And that should be part of whatever joint representation agreement, engagement letter, however you handle that. So what happens if the choice is keep all confidences? Well, the lawyer in this particular case now has, but cannot disclose, information that is material to the representation of one of the lawyer's clients, right? You've decided to keep all confidences. The lawyer cannot choose, sorry, I got 2 ofs in there, cannot choose one of the clients without breaching the duty of loyalty to the other client, right?
Right.
So the lawyer, and this is how Rule 1.7 works, the lawyer must withdraw from representing both clients. Now, what's the better approach? Well, maybe you like that approach. I personally don't like that approach. But what's the better approach? The clients and the lawyer pick an information flow rule from the very beginning of the representation. And what is that? What is the rule? What do most of you use?
Mine has a line that says, if you tell me anything that affects your estate plan, I'm going to have to tell the other one.
Yeah.
And I usually, at that point, also mention Charles Perrault, who was making a deathbed gift to his mistress of a farm.
Right. But Perrault didn't tell his lawyers about it.
No.
Right. He knew more. He knew better than that. Is that the practice of all of you? Do you have a share all confidences rule?
There might be an exception. I mean, it's, for a specific situation, but usually not in estate planning.
That's what I mean. For any kind of estate planning,
Very seldom.
I think it would be very difficult. I mean, you could do it that way. The rules allow you to do it. That's my point, because the rules separate sharing information from joint representation. And that's the reason that it allows for withdrawal of an individual upon the sharing of information that is material to the representation of the other client.
I certainly use
confidential. I allow clients to communicate with me, but I don't let it impact the estate plan that will impact either one. So I end up with information that sometimes is kind of confidential. A client came in and wanted to talk about being contacted by an agency where unfortunately a child in his early 20s had been born and wanted to come see him. He needed to talk to somebody, and I was happy to talk with him. Question was he going to allow it to happen? He decided not to. Is it relevant to the family? No. I'm never going to be the source of that. I continue to represent him, his spouse, and his children.
So unless or until you get information that would impact or express a desire to have an estate plan impact, you wouldn't feel under your arrangement. You wouldn't feel a need to share that with the other jointly represented client.
I would agree with I'm sorry.
Go ahead.
When I finish an estate plan, it's a one-off. I'm not going to represent them in other things. I usually send a closing letter,
Yeah.
which would end the relationship,
Right.
the client relationship with both of them.
Right.
Now the one comes back and says, I want to make this $250,000.
Right.
What impact do you think that has on the question you've asked?
Yeah. So I think that you still have some duties that run to that client.
I do too.
And I think now what you've done is that you have changed potentially this situation from being one of common or concurrent clients to one of serial clients, right? And you can't avoid the conflict with a client that you would have represented in another matter before. And I think you have represented this other one in the matter before. And there's now, correct. I think you would too.
Well, I think you,
Up here first. He was first. Yeah.
you know, I think you can differentiate between receiving information and taking action on that information.
That's what Case was talking about.
My question to you would be, do you have an obligation to share the information regarding the request that husband made with his wife, who may or may not be aware of the request?
In this particular situation?
I would not do it personally.
You wouldn't do what? You wouldn't share it?
I wouldn't go to the wife and say, you know your husband wants to give $250 to Barbara.
Now, let me ask you a question, because I think it's an interesting question, because do you think that that information which you have received materially affects your representation of that spouse, the wife?
Only if you're taking action on it.
And the husband.
Oh, personally, I think that it affects the material. I think it materially affects my representation of the wife,
And
because,
the husband.
Right, but he's the one who's revealed it to me.
But if you try to convince him not to give the money to Barbara, then aren't you affecting his?
No, that's right. So now, again, you're in that spot where you have information that materially affects the representation, and you are not in a position to effectively represent both clients as you should, faithful to their desires, right?
Isn't kind of premised on the assumption that they have a community estate? I mean, I practice in Texas where there's community property. If they had separate estates, then it doesn't seem like it would be, if they had a separate property agreement even, it doesn't seem like, it seems like each of their estate plans is an independent thing.
Yeah, where I am in North Carolina, and ours is a common law jurisdiction, so you would be drafting estate plans for both of them. You'd be drafting wills or revocable trusts for each of them.
You draft for both of them in Texas.
You would, but in this particular situation, you've got someone who obviously has separate assets, presumably of $250,000 in my jurisdiction, separate assets that you would leave to someone other than the surviving spouse. That was not part of the plan. That was not part of what the original decision was when those two got together and you drafted the documents.
But then does that mean that the initial draftings were contractual in nature between them? Because
No, it's not about contract. So it's not about whether there was a promise not to revoke and that promise has been breached. That may be a matter of litigation between them, but that's a contract question. What I'm talking about is the lawyer's responsibility here. The lawyer has now heard from a client, this is what I want. I want my estate plan to reflect $250,000 to go to Barbara, then I want the rest to go to my wife, and then whatever else happens, right? Now you have information that, in my judgment, is material to your representation of him and material to your representation of her. Because she now, would her decisions be different? That's the material representation issue.
Yeah, she leave him.
What's that?
Yeah, she might leave him.
You're right.
But it seems to me you've got the duty to conceal and maintain a client's confidence at all costs. And then you, as over this duty to disclose. And see, it seems to me, I thought you had the right solution. When you get that information, I don't think you can disclose it, but I don't think you continue to give wife any impression that you were still representing her.
Well, that goes back to the way that the rule handles it. The rule says you can jointly represent them. But the rule does not provide a joint representation equals share all confidences. That is not the rule. The presumption actually works the opposite way. The presumption is really a keep all confidence rule. So you can keep all confidences. I would say that this would be a confidence that has been given to you by one of your clients. You can keep that confidence, but if that information materially impacts the representation of another client, you can't pick and choose between them. As I understand the rule, go ahead.
Rule 1.7A, 1, says that the lawyer shall not represent a client if the representation involves a concurrent conflict, and a concurrent conflict of interest exists if the representation of one conflict will be directly adverse to another client. So now you have an existing set of estate plan documents, and now one of your clients is calling upon you to decrease by $250,000 the future inheritance of his wife.
Of the other client.
Of the other client, which is the wife. So at least assuming he dies first.
Okay.
So is that the kind of directly adverse representation that the rule calls for, even though it's prospective because it's only a testamentary transfer that hasn't occurred yet?
Well, if you've done the closing letter and at that point you don't represent the wife anymore, you don't represent the husband anymore either until you take him back as a client. So it's not concurrent representation.
If you've given the closing letter, but what if you haven't? What if it's a continuing course of representation?
How does that differ? How does that make a difference in terms of the sharing of information? Again, what I'm saying is you have decided, and I think rightfully decided, that you can jointly represent them initially. Right? Right. You are not telling the wife that she should get separate counsel and you're only representing the husband, correct?
Yeah, my point is not to the sharing of information aspect. It's as to the ability to continue to represent both of them. Because now, isn't he asking you to take action in representing him that would be directly adverse to her?
I think so.
And doesn't that, and you can't, the only way you could then continue to represent both of them is to get an informed consent in writing, which means telling her.
Right, the disclosure, right. So that, and to me, that's what the rule actually drives toward. It drives in the direction of withdrawing representation from representing both of them. You don't get to pick and choose, or you don't get to pick the one who gave you the information first, right? Or the one who may produce more, more fees in the future. You don't get to make that choice. You now have, in my assessment, you have information that is material to the representation of that wife in her estate plan. She should know this information, I think. It is relevant to her. Now, my point is, you don't have to disclose. That's the point of this. You jointly represented them. You didn't settle the disclosure or the sharing of information rule. Presumptively, what you've got is a keep confidence, and when you get that information, now you have to stop representing both of them is the way I understand the rule, right? Okay, that's a separate, but the share of information is a separate question. It's what creates now the inability of you jointly representing, because now you know with a certainty that you have material information that impacts the representation of another client, and you do not have the ability to disclose it. That's why, in my estimation, the better rule is a share all confidence rule. Now, what's the downside of the share all confidences rule?
Broken marriage.
Right.
Maybe, I was going to say, is that really, yeah, well, it's going to work out to, there are going to be collateral consequences at some point. Okay, but what else?
You're not going to share all these.
There you go. That's the one. That's the real one. If you disclose to, and you agree with the clients, anything one of you tells me, I'm going to tell the other. If it relates to this estate plan, now you have just forewarned, right? You have just said, don't tell me about it. And of course, there are those occasions when individuals get the phone call, lawyers get the phone call from one of the clients, and after the pleasantries, the client says, hey, I've got something I would like to talk to you about. Now, if you have a share all confidences rule, if that was part of your joint representation agreement, what do you say?
Hold on, I got to remind you, anything you tell me, I'm going to tell your wife.
I think that's the right thing to do, and you would do that for both of them. Yeah.
So I want to throw a hot potato here.
Oh, no.
We've been analyzing this under the ABA rules.
Yeah.
In the same way we would do if this were a secular conference. But this is CLS. So, as a Christian attorney, if the husband came to me and said, I want to change my estate plan and give $250,000 to my secretary, so that raises a moral, not an ethical, but a moral dilemma on my part, because is he actually favoring a paramour, or is he favoring just a very loyal and competent employee? And if it were the latter, he shouldn't have problem telling his wife.
Correct.
And if it's the former, I wouldn't do it. I'd say, I'm no longer your attorney because you're engaged in an adulterous, or if I knew this, adulterous relationship, and I'm not going to facilitate that. Go find yourself another lawyer. And that's the Christian. That's my Christian dimension over and above whatever the secular ethical rules.
And I think, and I don't disagree with you, and I think what happens in that situation is you either share the information because that's what you've agreed to, or you don't share the information, you withdraw from representation. But your representation of him doesn't mean that you stop counseling him. That's a separate question. I'm not counseling you as to the law any longer, right? I'm telling you, I'm reminding you that you are on a dangerous path, my friend, right? If you continue on this dangerous path, not only will you lose your marriage, but you are actually in danger of losing your soul. That conversation can happen. But that's not, you've already solved the legal representation issue. We've handled that.
And the ethical rules allow that kind of
They do.
moral
They
and
do.
personal counseling.
They do. They do it. They allow it within the representation. But in my scenario, the representation has ended, and I'm not getting paid for this, right? This is not part of my legal representation of you. This is my counsel to you as a brother or a sister in Christ.
The only tough thing is, what if you're also an elder in his church?
Yeah, well, he wouldn't have called me with that one. that was my experience. My experience is I don't hear that from the lawyer client.
You bill him for the time.
I don't.
Push it just a little bit further, and it's something that you end up saying, look, I can't do that unless you both come in and we do this. And he says, okay, then, yeah, let's forget it. Because, let's say, it didn't have that other moral dimension. And so in those cases, when the client backs off, I've certainly continued the representation.
When the client has simply said, I'm not going to do it?
Yeah.
Okay.
Yeah, I think, that's probably a good idea. I'm not going to do it. Because I said, I can't possibly do that for you. Come on in together.
Right.
And backs off.
Right.
I continue the representation.
And then, but still that backs up to the question of what did you decide you were going to do with that information, all the confidences that were shared, right? In your scenario, you said, I will reveal only that which materially affects your estate plan. But if it doesn't materially affect your estate plan, in my judgment, then I'm not revealing that information. I think you could craft the rule that way. The ABA rules, model rules, actually view, again, those two things as separate. Joint representation is one issue that you can resolve easily enough. Second issue is sharing information. How have you decided to do that?
Can we modify your...
Am I hypothetical?
Your hypothetical to provide that 250 was coming from an inheritance that he received from his deceased father?
Okay.
Not part of what...
Now separate property of some sort? Yeah. It's possible. I mean, you might. I still think it's materially, and I think it still materially plays a role in the representation of that wife. I think it does.
Morally, too.
I do, too.
I think you have to encourage him, you need to consult.
Yeah.
Think about what the wife will think.
Correct.
When her husband dies and the will is read. I mean, I think that really is.
Why didn't you ever tell me?
Why didn't you tell me? Yeah.
I think that's right. And I mean, would that information affect how she would proceed in these things? I think the answer is clearly yes. It would affect how she would proceed. Yeah. Okay. Now, the unauthorized practice of law, the last component that we have here. In doing a little investigation on the unauthorized practice of law, and I put this in the outline, it actually has a disputed history. Some folks claim that the idea of limiting particularly the sort of transactional dimensions of the practice of law to lawyers is of relatively new, or is a relatively new invention. By relatively new invention, I mean latter part of the 19th century, beginning and to a large extent through the first half of the 20th century. But before that, there is a considerable amount of evidence that it was not the common practice to limit individuals participating and assisting other individuals in a lot of different things that we would now understand to be part of the practice of law. It's interesting, too, and the authors that I read trace this back to the same period that where there's been a significant turn in legal ethics generally. Tom Schaefer, does anybody know that name? He was at Notre Dame for a long time, law professor, legal ethicist. Tom Schaefer wrote a law review article. It was published in Tennessee Law Review that I would commend to all of you to read if you've never read it. It's called The Unique, Novel, and Unsound Adversary Ethic. Unique, Novel, and Unsound Adversary Ethic. And in that article, Schaefer tries to do good historical work in how the idea of legal ethics changed after the Civil War in the United States until the first quarter of the 20th century, during that same period. And one of the interesting things that he points out in that case is, or in that article, is that law was not organized primarily in firms in any significant sense until after the Civil War in the United States. It was much smaller. A firm, a big firm might be one or two people, or 2 or 3 people. It was not big firms. There also were not bar associations as we know them now. That was an invention that comes along after the Civil War. And he connects, Schaefer connects in that article, the changes in the rules of ethical conduct for lawyers with the Gilded Age and robber baron period. And he actually makes a case, whether he's right or not, you can judge for yourself. He actually makes a case that the laws related to lawyering, those legal ethics rules, were designed to provide protection to lawyers who were representing robber barons. And he makes a pretty good case.
What's his last name?
Schaefer, S-H-A-F-F-E-R. He makes a pretty good case for that, that these were lawyers figuring out ways to define their roles such that it worked to their financial benefit. Now, because I have Calvinist theological commitments, that sells to me, because I believe in total depravity. That I think we all have a tendency to write rules that, despite our inclinations to otherwise, apart from the power and work of the Spirit, we're going to write rules that are actually self-interested. And so it's interesting to compare Schaefer's assessment of what happened there with the development of unauthorized practice of law rules. Because if Schaefer's correct, law firms gathering lawyers together, and then law firms themselves gathering together, as it were, in associations designed to protect themselves from outside criticism and developing the rules of the practice to their own benefit, that's his argument. Well, it's not very far from that to the unauthorized practice of law rules. Do you understand what I mean?
Sure.
That if that's happening here, it's not surprising at all that unauthorized practice of law rules also develop at the same time. I haven't studied that any more than that, but it's just an interesting idea.
Always been a knock against licensing laws, that the purpose of licensing laws is to limit ingress to a particular profession or trade.
Right.
Barriers to entry. So
Right.
what happened to Abraham Lincoln State? He read the law, and then I'm just curious, I don't know.
Yeah, he would have read the law, but one of the other things that Schaefer in his article says about the nature of law practice is that, and this is his title, Unique, Novel, Unsound Adversary Ethic. He said the adversary ethic does not actually enter our understanding of what the role of lawyer is until the middle of the 19th century. Before that, the ethic of the practice of law was far more interested in the common good than it was being driven by the sole interest of client. It's a fascinating piece. I commend it to you. It's worth reading, and it's not that long, which may make you more inclined to do it. Yeah.
Just a little bit of an example of that, I think particularly for people in the estate planning and probate world, up until about 76, 77, somewhere in there, all probate fees were determined by fixed fee schedules put out by bar associations. I think California and Florida still have statutory, and the Supreme Court struck those down as being
antitrust.
Yeah, and violating antitrust.
Yeah.
But what was fascinating, I was a young attorney handling the estate of a grandfather, needed some help from a lawyer in another state, elderly lawyer, good Christian lawyer, said, oh, I'd be glad to help you on that and handle a probate proceeding. I said, okay, what's it going to cost? He said, well, I'm not going to charge you a dime. Good old Joe, I'm delighted to do that for him. And I said, you just charge it. I said, well, I'm doing this for my spouse's grandpa. I'm not going to charge either. Oh, I can't do that. I'm violating my moral obligation to my fellow attorneys. And of course, it was about a year later the Supreme Court said, violation of anti-competitive practices. So how Christian lawyers had turned moral principles on their head, because I felt awful in some of these cases where my big law firm was doing very little and getting a big
fee. Yeah. Yeah. So anyhow, the field of unauthorized practice of law is governed by two different sets of rules that do intersect. First set is where the lawyers are policing lawyers, so our model rules, the rules of ethics. But remember, the rules of ethics apply to lawyers primarily, right? So they're not actually applicable to the person outside. That's not the model rules. And then you have state statutes that actually deal with the unauthorized practice of law, that specifically discuss the unauthorized practice of law. So I've tried to include a fair amount of material there in the outline. I've included statutes from Alabama. I've included a California statute. I've included my home state of North Carolina in that as well, just to give you a flavor of the type of unauthorized practice of law statutes in the various states. Interestingly, the state statutes vary to a significant degree. And we'll touch on some of that. So I think that there are three principal or primary issues that the model rules address. One is jurisdictional limitations. In other words, how much can a lawyer licensed in one state do in another state for a client? That's a jurisdictional question that the model rules address. That's an unauthorized practice of law issue. It's framed because you're not licensed in that other state. So the question is, how much can you engage in assisting a client who's in another state where you are not licensed? Second question that I think the rules try to address, although I'm going to say this, I've probably forced something on the rules that may not be there. I'm not sure that the structure is there, but I think it's helpful, at least it was helpful to me as I thought through it. It's really kind of duty of loyalty issues that the rules address, and I think you'll see this. So it asks the question really, under what circumstances, if any, can a lawyer enter into arrangements with a non-lawyer where all or part of the activities of the parties would include the practice of law? What am I talking about there? Well, this is a fee-sharing arrangement, right, with non-lawyers. That's an unauthorized practice of law issue. Why? Because it's a duty of loyalty issue. Why do I say it's a duty of loyalty issue? Because it creates the conflict between what is of the best interest of the client and what is the best interest of the lawyer. That's the issue in that part, that collection of the rules. So it comes down to, can a lawyer be directed in the practice of law by a non-lawyer? If the non-lawyer creates a compensation arrangement or, I think I'll just, a compensation arrangement or a way of making more money that actually instructs the lawyer in doing something contrary to the interests of the client, that's the duty of loyalty issue. The lawyer has the duty of loyalty to the client. That shapes what the lawyer is going to do. If that's in conflict with the non-lawyer, the unauthorized practice of law rules of sorts for the model rules would apply. And then the third principal issue that the model rules address, I think, is the use of non-lawyers by lawyers, where lawyers improperly use non-lawyers to perform law-related activities, legal services, or provide legal services. The fourth issue, which is not addressed, in my judgment, directly under the model rules, but it's addressed under the state law. That fourth issue is the provision of legal services by non-lawyers. That's what the state is interested in under their state statutes, because the justification for the unauthorized practice of law statutory rules is consumer protection. Consumer protection, right? So that's why the state laws can apply beyond the non-lawyers. Model rules are applying to lawyers. These are the ethical responsibilities that you undertake. If you are licensed to practice law in a particular jurisdiction, you're subject to those rules of discipline. If you're not the lawyer, now the state is interested in what you do, because what you do will have impacts on the consumers, the citizens of the state. Consumer protection, okay? So let me go back to something that I mentioned earlier, and before we go on to the couple hypotheticals. I mentioned before that the state law rules vary significantly. If you look at Alabama, for example, Alabama says it's an unauthorized practice of law if you receive compensation for your services, if you're not a lawyer. That's nowhere to be found in the North Carolina rules. California also has a rule, those of you that are here from California, also has a rule apparently where it is almost a per se, I think I'd read it this way, a per se violation of the unauthorized practice of law if you hold yourself out using certain titles that in Hispanic communities are titles that lawyers use. Okay? So that, go ahead. Okay. So that happens in jurisdictions where those issues have arisen. North Carolina has recently changed, in the last 2 years, changed its unauthorized practice of law rule because of litigation involving LegalZoom. And so now the unauthorized practice of law in North Carolina does not include the delivery of some law-related services through a website, as long as, and here are several conditions attached to it. Not every jurisdiction has that. Why? Because it hasn't come up. I mean, it's come up, but they haven't resolved it the way that that particular jurisdiction has resolved it. So there is a considerable amount of variation in state statutes regarding what constitutes or does not constitute the practice of law, and therefore the unauthorized or unlicensed practice of law. So let's do this hypothetical. This is, I've labeled it the Snowbelt Sunbelt problem. Estate planning clients of X move from the snow belt, where the lawyer is licensed, to a Sun Belt state. That's never happened before. Thought I'd just make up a true hypothetical. They have no intention of returning to the snow belt. After the move occurs, the clients ask the lawyer to revise their estate planning documents. All their communications are by phone and email. Satisfied that the documents are as the client wants them, the lawyer flies to the Sun Belt to oversee the execution of the documents in the client's new home. Does that constitute acceptable practice under the state unauthorized practice of law rules and under the rules of ethics, typically rules 5.1 through 5.7 of the model rules? It's interesting.
I've set up revocable trust for clients that have moved to other states, but I always advise them that they should consult a local attorney and have them prepare a will and review the trust.
Okay.
I do it regularly, and the...
You travel and executing the document?
I generally don't travel.
Oh, okay.
I mean, I send them down and so on, and I know that I think the ABA rules are a little bit hard on that, but there are, I think the ACTEC rules are much more open to that.
The ACTEC commentaries on the model rules would certainly allow for this particular practice. And I've run out of space here, but actually if you look in the outline, if you look at the Restatement of Law Governing Lawyers, Section 3, I've reproduced that, and I've reproduced some of the comments to that, which are informative because they use almost exactly this situation. And they say, we don't, the restatement says, we don't see a problem with this.
Yeah, I always thought it was basically where your office is. As long as your office is in Illinois, then you can do whatever you can do. You know, you can represent a client and buying a business in another state.
Right, and actually you can look at the rules. The model rules allow for some of that, you are actually in a position where you can make assessments of the law of some other jurisdiction. And as I mentioned, these, the restatement rules, the ACTEC rules provide a wide opportunity for lawyers to engage in that kind of multi-jurisdictional practice.
In this particular inquiry especially, I think the model rule isn't necessarily very helpful because the state statutes are all over the place. I had occasion to compare California's rules. So I'm licensed in Illinois, and I had a team association in Michigan and another one in California where my daughter lives, and they both needed representation. The Michigan statute plainly states that licensed attorneys in other states can practice Michigan law for Michigan clients, provided they do not have an office in Michigan, and with the further exception, they can't practice in Michigan courts.
Right.
Otherwise, you can do it. Well, California, if I did it in California, I'd be prosecuted.
Well, see, that's the interesting thing, and that's why the ACTEC rules, in my judgment, actually are a helpful gloss upon the multi-state, upon the model rules, because the model rules allow for things like temporary appointment before a tribunal. Well, you can't get a temporary appointment to go down to execute the documents, right? So the ACTEC rules are designed to say, well, couldn't you do something that is even maybe less significant in terms of representing a client before a tribunal? Why would we have to associate counsel? And so I just commend them. We're kind of running very short on time, so I'd commend them to you.
California does have a court of appeal case on a probate matter where the client, the executor, was, I think, Colorado in that case, but out of state.
Yeah.
Hired a Colorado attorney to help them so they could interpret what was coming from the probate attorney in California, who was actually doing the probate work. and the Court of Appeals said, that's okay, but the total fee cannot go above California statutory fee.
Okay, okay, got it. Last question is one I'll leave you with. So this is in part kind of the early stages of what happened in North Carolina. How many of your jurisdictions have, under the bar associations, your jurisdictions have a Wills for Heroes program? Okay. So North Carolina developed this. It started out of the Young Lawyers Division. It actually started out of a few of the Young Lawyers Division lawyers. So a group of lawyers licensed in the jurisdiction decide to provide free estate planning documents to first responders, police, fire, EMS. They choose a date and location. They engage the help of non-lawyers. In my jurisdiction, they try to get as many law students as possible to participate in this and to find some notaries. They train the non-lawyers on the use of a document assembly system, so there are people who are taking data in, right? Here's the questions that you ask, and you add your data to it. Eventually, the whole thing comes together. When the day of the event arrives, the lawyers are present, but the non-lawyers interview the first responders using questions provided through the document assembly system. After the interview is complete, the documents are generated, and then they're executed in the presence of the necessary witnesses with an accompanying notary, because we have the affidavits that are customarily attached to make self-proving wills. And the lawyers are present during the event. They're all around. They're available to answer questions if any of them arise. And I changed the facts here. A small fee is paid by part of the first responders to cover some of the costs of doing this. Not the lawyers' fees. They don't get paid. All right? So how do we handle this as an unauthorized practice of law question? Is it within the definition? I just asked these questions. Is it within the definition of the practice of law? If not, why not? You look at the statute to see whether it is or is not. If it's within the definition of the practice of law, the 5 lawyers and the recipients of the forms, have they formed an attorney-client relationship or not? And then what are the consequences if they have? If they have, is the question whether the lawyer's responsibility now to direct non-lawyers in the provision of legal services. Now, here's the interesting thing, right? In North Carolina, for example, we've solved the legal Zoom issue by crafting a statute that allows for that to happen, right? That's not understood to be the practice of law. And so we don't have to bar it as the practice of law, because we don't bar it because it's not the practice of law.
Why is it not the practice?
Because of the statute. That's the positivist version of that, right? It is not the practice of law because they were sued and they were worried about what the consequences were, and so they settled on this proposed language, which was endorsed by the legislature of the state. And in essence, what they got in that case was this. They got this. A North Carolina lawyer would have to review the documents that are produced by that website. That, if that happens, and if they disclaim that they are engaged in any practice of law, and if they don't make any representation that any kind of attorney-client relationship exists, it's not the practice of law under the law of our state. Okay?
I think this one is pretty clearly practice of law. It isn't all that much different than all most of us use legal assistance.
Right.
Paralegals.
Well, and so the question is not, I mean, the question in many ways is this question: has an attorney-client relationship? Because if an attorney-client relationship has been created, then all of the things of the attorney-client relationship attach, right? And if that attorney-client relationship has been created and all of those things attach, then conflicts and all of those other issues, confidentiality, flow of information, all those other things attach too. If the attorney-client relationship exists, then certainly, in my judgment, the attorneys can use non-lawyers to assist them in the delivery of legal services, correct? The question is, can you do it without attorney-client relationship being attached? Well, thanks very much, folks, for